And is plaintiff here?
Yes, I am, Your Honor.
Okay. All right. And where are we on this case? Almost afraid to ask, but
Yes, we recently sent our interrogatories and document requests to Mr. Johnson. So we'll just be waiting to hear back from him on those.
when did you send those to?
We sent it to his email address, and we also sent it via mail.
But when did you do that?
We sent that today.
Oh, you just sent them today. Okay.
And then we also plan on filing a motion shortly for lack of personal jurisdiction.
Leave it to these law students. Well, okay, what do you mean lack of personal jurisdiction?
Yes, we believe that we have a personal jurisdictional issue in today's case because the plaintiff asserts that he personally served a notice to quit to Ms. Walker on June 20th, 2023. But Ms. Walker has made it clear that other than like appearances in the court, she's not seen the plaintiff since January 25th of 2023. And if this is true, then it should establish that there's a lack of service and then a lack of personal jurisdiction.
Don't want to make a legal argument with you, but is it really personal jurisdiction?
It's supposed to be lack of service.
Oh, yeah, I know, but you're saying there was no notice to quit. Is that really lack of personal jurisdiction?
Just lack of jurisdiction in general.
In general.
Right. Just lack of jurisdiction.
Nice save. It was like he was in the classroom and all of a sudden it's probably going to be lack of subject matter jurisdiction because he hasn't invoked the jurisdiction of the court, but that's okay. You'll figure it out. All right. How long will it take you to get that motion in? Maybe we can solve it right now. Mr. Johnson?
Yes.
It says that on June 20th, 2023, that you personally served on Miss Walker a notice to quit. Did you hand a notice to quit to her?
Yes.
You did?
The sheriffs gave it to her.
No. You signed, I'm not talking about the lawsuit itself. I'm talking about the notice to quit for non-payment of rent.
Yes.
You handed it to her?
No, I didn't hand it to her. It was mailed to her.
Well, hold on. Because we're going to have a problem here, Mr. Johnson. Because the proof of service on the notice to quit or demand for possession says that you delivered this to her personally.
I put it on the door at the house.
Okay, well, there's a problem also. Because now you told me that you handed it to her, but then you said, no, you mailed it. And now you're telling me you put it on the door.
All the stuff, because I knock on the door, she doesn't answer, and the people at the court told me to just put it on tape it onto the door.
Oh, no, so don't blame the court. They didn't tell you that. Mr. Johnson.
Yes.
I need you in the camera.
I'm right here.
Raise your right hand.
Yeah.
You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
The demand for possession in this case, did you serve that on Miss Walker?
I put it on the door because she would not answer the door.
You put it on the door,
I taped
meaning
it on the
you
door.
taped it to the door?
Yes, sir.
Pardon? Mr. Johnson. Mr. Johnson? Really? Mr. Johnson,
I'm here.
you put it on the door.
Yes.
You taped it to the door?
Yes, sir.
So why does your proof of service indicate that you delivered it to her personally to the person in possession?
I didn't say that. I didn't. Who said that?
I'm looking right at it, Mr. Johnson. The box is checked. That you served a demand for possession personally to the person in possession.
Well, I must have checked the wrong box then, Your Honor.
Well, gee, Mr. Johnson, because there is not a box, Mr. Johnson.
But she never
There
answered the
is
door.
not a box for taping it to the door.
If she doesn't answer the door, I had to tape it to the door.
Okay, we've gotten past that. You told me you taped it to the door because she won't answer the door. Okay, I don't know if that's true or not, but let's assume it's true. What I'm telling you is that you represented to the court that you personally delivered it to her and signed it. And that's not true. That's point number one. Point number two is taping to the door the demand for possession is not a proper form of service of the demand for possession. You understand that, Mr. Johnson?
Yes, but the officer tried to give it to her too, and she wouldn't answer the door.
What officer? In this process for the demand for possession, there's not an officer involved. You signed a document that you submitted to the court indicating that you served on Ms. Walker this demand for possession on June 20th, 2023 by delivering it personally to the person in possession. That's what you signed. That's what you submitted to the court. And based upon what you just told me, that's false. And then even what you tell me is not proper service for the demand for possession. So here's the problem. And now, counsel, this is where you were going to go when you were going to type it on the paper, but just stay with me. In order to invoke the jurisdiction of this court for this type of proceeding, I have to have a proper notice. That proper notice must be served upon the person. By your testimony, I don't have a proper notice. Therefore, the subject matter jurisdiction of this court, since I'm a statutory court, has not been invoked. This case is dismissed. The court lacks subject matter jurisdiction. Thank you.
Thank you, Judge.
Thank you.
Thank you, Your Honor.